Hello everyone and welcome to Module 11, Educating Employees and Employers on Employee Rights and Protections. Today, we will be looking at an introduction to national case law. The aim of this presentation is to give an overview of the rights of employees based off of defining case law. By the end of this presentation, you will be able to discuss employee rights and protections as applied to the workplace, based on national employment case law. This presentation will explore the EU Charter of Fundamental Rights and its role in shaping employment protections across the European Union. Specifically, we will focus on key articles within the Charter that are directly relevant to employment equality. Next, we will look at workers' rights in the EU, highlighting the importance of understanding employee rights and protections under EU law. The presentation will also look at the contributions of the European Commission in shaping and enforcing labour law, as well as the role of the Court of Justice of the European Union in interpreting these laws and setting critical precedents. The EU Charter of Fundamental Rights was proclaimed in 2000 and became legally binding on EU member states with the Treaty of Lisbon in 2009. It consolidates rights that are fundamental to European Union law, particularly in employment contexts. The Charter strengthens protections for employees by providing a unified framework that all EU member states must observe. It influences national laws and shapes judicial rulings to ensure that fundamental rights are respected in employment practices across the EU. EU Charter of Fundamental Rights. Key articles relevant to employee rights. Article 21. Non-discrimination. Any discrimination based on any ground such as sex, race, colour, ethnic or social origin, genetic features, language, religion or belief, political or any other opinion, membership of a national minority, property, birth, disability, age or sexual orientation shall be prohibited. Within the scope of application of the treaties, and without prejudice to any of their specific provisions, any discrimination on grounds of nationality shall be prohibited. Article 23. Equality between men and women. Equality between women and men must be ensured in all areas, including employment, work, and pay. The principle of equality shall not prevent the maintenance or adoption of measures providing for specific advantages in favor of the underrepresented sex. Article 31. Fair and just working conditions. Every worker has the right to working conditions which respect his or her health, safety, and dignity. Every worker has the right to limitation of maximum working hours, to daily and weekly rest periods, and to an annual period of paid leave. Article 34. Social Security and Social Assistance. The Union recognises and respects the entitlement to social security benefits and social services providing protection in cases such as maternity, illness, industrial accidents, dependency or old age, and in the case of loss of employment, in accordance with the rules laid down by Union law and national laws and practices. Everyone, residing and moving legally within the European Union, is entitled to social security benefits and social advantages in accordance with Union law and national laws and practices. In order to combat social exclusion and poverty, the Union recognises and respects the right to social and housing assistance so as to ensure a decent existence for all those who lack sufficient resources in accordance with the rules laid down by Union law and national laws and practices. Influence on case law. These articles often guide the interpretation of EU directives related to employment. Courts refer to the Charter when ruling on cases involving workplace discrimination, fair treatment, and equality, further establishing the Charter as an integral part of employment rights law. EU Charter of Fundamental Rights influence on case law. In the Court of Justice of the European Union, Case C. 414/16, the EU Charter's Article 21, non-discrimination, played a significant role. This case involved a job applicant who alleged discrimination based on her lack of religious belief, arguing that her non-religious status should not affect her eligibility for employment. The court used Article 21 to interpret the Employment Equality Directive, confirming that employers cannot impose religious affiliation requirements unless they are essential for the role. This judgment showed how the Charter directly informs decisions in employment discrimination cases, reinforcing anti-discrimination rights within EU law. The CJEU relied on the Charter's principles to ensure that non-discrimination in employment remains a fundamental right across the EU, providing precedent for future cases involving similar claims. In the EU, fundamental rights are protected both by each member state's own legal system and by EU law through the Charter of Fundamental Rights. The Charter applies whenever EU institutions, like the European Parliament, take action, especially in legislative processes, and also applies to member states, but only when they are implementing EU law. The Charter complements rather than replaces national systems, linking EU law with national actions. It does not replace national fundamental rights systems, but complements them. For example, this connection exists when national laws implement an EU directive, when a public authority enforces EU law, or when a national court interprets EU law. If a national authority violates these rights while applying EU law, the European Commission can initiate a process to correct this, potentially bringing the issue to the Court of Justice of the European Union, to ensure that national laws or practices align with EU requirements. Workers' rights in the EU. Every EU worker has certain minimum rights relating to health and safety at work, equal opportunities for men and women, and labour law. Individual EU countries must make sure that their national laws protect these rights laid down by EU employment laws. Importance of knowing employee rights and protections. Understanding employee rights and protections is essential for both employers and employees. Awareness of their rights and protections helps employees recognize and address workplace violations, reducing instances of discrimination and unfair treatment. The European Commission and labour law. The Commission ensures that EU directives are incorporated into national law and monitors their correct implementation. If the Commission finds that a country hasn't properly incorporated a directive, it may start infringement proceedings against that country. The European Court of Justice and Labour Law. When a dispute in a national court involves interpreting an EU directive, the court can refer the question to the Court of Justice of the EU. The European Court provides the necessary answers to help the national court resolve the dispute. Case law is defined by the Oxford Dictionary of Law as the body of law set out in judicial decisions, as distinct from statute law. This refers to the set of laws created by court decisions, rather than laws written and passed by legislative bodies. These judgments are reported in publications such as the Irish Reports and Digests. Some judgments go unreported. EU case law is made up of judgments from the European Union's Court of Justice, which interprets EU legislation. This presentation looked at the rights of employees, focusing on how they are shaped by national and EU case law. The EU Charter of Fundamental Rights, which became legally binding in 2009, was discussed in terms of its influence on employment law, especially through provisions that prohibit discrimination, ensure equality, and uphold fair working conditions. Here you can see a list of the references used throughout the presentation. These sources will assist you in researching more deeply into EU employees' and employers' rights and protections. Thank you for listening. I hope this presentation has provided you with a deeper understanding of EU employee and employers' rights and protections.